Dear colleagues, greetings. Today, on December 6th, 2025, the advisory group of experts gathered in full to conduct an interview with the candidate for the position of judge of the Constitutional Court of Ukraine, Prydatko Vitalii Mykolaiovich. In particular, all 6 members of the advisory group of experts are present. Secretary Maureen O'Connor, members of the advisory group of experts, Hanna Sukhotska, Alice, Zara, the member Hanna Sukhotska, me, Vasila, Oksana Sukhotska. Also, during this meeting, we have 4 deputy members: Mr. Volodymyr Kuzmenko, Vitalii Mokhinchuk, Richard Barrett, Thomas Griffith. I would like to note that we are working in a shelter, so in the event of an air raid, the interviews will continue without interruption. I would also like to remind you that the interview is being recorded and broadcasted live on the resources of Advisory Group of Experts and the website of Constitutional Court of Ukraine. Therefore, I draw the attention of the members of AGE and candidates to the restriction of the use of sensitive data and information with limited access on live broadcasts. If necessary, the AGE will limit the broadcast for this time. We're ready to begin, so I will hand over the floor to the Secretary of the Advisory Group of Experts, Maureen O'Connor, for a brief introduction of the candidates and reminder of the interview procedures. The floor is yours, Maureen.
Colleagues, to everyone who is watching us today. As our chairwoman has already said, the advisory group of experts will now interview the candidate Prydatko. Let me remind you that the interview is part of the stage of evaluating candidates in order to establish their compliance with the criterion of high moral qualities. As before, each interview will take approximately 1 hour. And the time limit for answering questions is no more than 3 minutes. Traditionally, we ask all candidates to be concise, to answer the questions posed clearly, unambiguously. Materials about candidate Prydatko, the AGE, materials about candidate Prydatko, the AGE, the advisory group of experts, sent him questions for written explanations. So the candidate has had the opportunity to prepare and to provide answers. So I will briefly introduce our candidate. He is a judge of the Korolyets District Court of Sumy region. He is a lawyer with over 15 years of professional experience in the field of law. Mr. Prydatko, if you would like to add something to your presentation, your background information, you can do so now with up to 3 minutes.
Thank you. No, I think I have no additions, so we may continue.
We'll then turn it over to Mr. Romanik to begin the questions.
Dear Vitalii Mykolaiovich, I have some questions for you. I want you to give us brief answers to these questions. The advisory group has analyzed the electronic declarations for 2015-2022 that you indicated ownership in these electronic declarations. You indicated ownership of a residential building located in village of Krasnopilya with the total area of 70 square meters, and the land plot located in the same settlement with the total area of 530 square meters. As you indicated in your declarations, you acquired ownership of the relevant real estate on October 30th. What are the circumstances of your acquisition of ownership of the specified real estate objects? The circumstances I already explained in the first round of session. Thank you. We know it all, but for all and for those who is observing right now us, who's watching us broadcasted live. Okay, briefly. The household. The address Ostrovska, now Alexandra Shkurka 9, in the village of Krasnopila. It was built by my great-grandmother in 1970s of the previous century. And then my grandma married with Makarenko Mikita Sergeyevich. She died in February of 2008. Makarenko Mikita Mikitovich asked us to give him assistance as a family members. So, as much as he can be considered the family, he thought we were obliged to provide to him assistance because he felt like he was helpless, and then he went through the medical treatment. He had hypertension, from his words. In 2008, we moved to this house. We lived there until 2025, but according to different circumstances, of course. In 2013, Makarenko Mikhailo Mikitovich offered to purchase this house. He wanted us to pay some sum of money. He's referred that he also has the father's house not far from Krasnopila. And finally, this lasted for some time. And in October of 2013, we got money and we paid for this house. We purchased the house and the plot of land, 530 square meters. But in the future, Vitalii Mykolaievich, if briefly, let me continue with my question. My questions further will be posed according to the information that is in the court's decision, according to the case number 578/817/820. In this court's decision, it says that in the house since 1969, citizen Makarenko lived, about which you have just mentioned. In 2008, you and your wife, you offered citizen Makarenko to take care of him. He agreed. You and your wife, you moved into the house, and you were registered in this building. In 2013, with Makarenko, there was an agreement of the purchase of the building that was signed. But, however, as the court's decision states, you acted not in a good way, because citizen Makarenko counted that in exchange of giving you into property the house, you will take a commitment on yourself to take care of him and take care of the citizen Makarenko. However, in some time, in 2019, you moved him to the nursing home. How can you comment this situation, that you sign the agreement of the purchase and Makarenko, in course of 6 years, continues to live in this building, even though you said he had another house in his property? He states that you had to take care of him, and this is stated by the decision of the court. Instead of that, you put him in the nursing home. From there, his relative further took him for further caring. How can you explain these circumstances? Okay, step by step. First of all, the circumstances of the case, who offered to who. Yes, they were established in a right way, and they were grounded on the basis of explanation of the notary, only in that decision that was made preliminary. As we know, the court decision that you are referring to was not the first one. The court decision was made before the Pisarev court, by which they refused to acknowledge this. I am working with the information which is in the final court decision. Excuse me. If this is the final decision, even if we go to the content of this decision, it has three different options of explanations of the notary. To rely on the circumstances which lay down in the basis of the contract, Vitalii Mykolaievich, we're not talking about a description of notary. We're talking about circumstances which are established by the court in the name of Ukraine, on behalf of Ukraine, by the results of the analysis collected in the evidence. These are circumstances that are being stated. How can you comment them? I'm commenting them in the next way. On the 14th of August, 2024, Supreme Court has put a period in this trial, in this dispute. With the resolution of the Supreme Court, it stated that the agreement was unreal because of the mistake of the person who sold the house. According to the civil code, the mistake envisages any kinds of faults in one party, the party that makes mistakes. If I acted with not a good will, as it states in this court decision that you refer to, I did not do. This was not established, and not in any first instance court, in cassation court, about the bad conduct on my part and my wife's conduct in any way. It's not. We're not talking about this, but of course, Supreme Court stated that there was a mistake from the part of the person who sold the house, and we have recognized this decision. We submitted according to the Article 129.1 of the Constitution, and this is final. About submitting to this decision, okay, there will be following questions, but now I still want to clarify the situation. If Makarenko, according to the sales agreement, he does not have any, you don't take any commitments on yourself, you just paid money for the purchasing of the house, how can you explain that in course of 6 years after this agreement was signed, he continued to live in this house? Because as you state, he has another house. If this was not the agreement of the life-lasting care, where you had to take care of him, it's just the sales agreement. You give him money and he gives you house. Why then he continued to live there for 6 years? In this question, I can only answer for myself, because to give the answer why he didn't move out, this would have to be the question for him, not to me. He lived not in the house, but he lived in the specially equipped kitchen, not in the house itself. It was an addition to the house. At first, he asked us to stay, and then he had separate heating. Okay, it's clear. But under circumstances of this case, which is identified by the court, your wife and you put him into the nursing house. It was not his voluntarily move, but you placed him to the nursing home, correct? In order to... Okay, now we happen to be in an interesting collision track, where I can identify circumstances that comply with reality, or I can work with circumstances that are stated in the first instance court. Makarenko wrote the application voluntarily to be put to nursing home. It's not even the nursing home, it's the special home There were some issues of the cognitive matter as of 2019. He had conduct which put to threat in his summer kitchen, in a specially equipped facility. He had a gas stove, and he had a tendency to leave it open, like the gas was on for a long time. It was a threat for his life, and in one court, and in one address, it was the threat to me and my child, because my child was quite young at that time. I understand. Okay. Vitalii Mykolaievich, you state that you submitted to the decision of the court. The court's decision entered into force in May of 2024, but you continued to live in the house. Moreover, you already did it to the decision. It's 578 decision /817/20. So after a second review by the Civil Court of Cassation within the Supreme Court by a final ruling in this case, your cassation appeal and that of your wife were dismissed. He thought he was giving you the house in exchange of you taking care of him. And you did not do this. The next decision of the court comes to the order that they take off from the registration. So how do you explain the circumstances in of the relevant situation? You are the judge, but you continue to use this house not until the moment when decision in the new case on the forceful eviction comes. How can you comment this in the context of respect to the court's decision?
According to the first decision, the agreement was considered null and void. Neither myself nor my family had no other premises for residency. In spite of the regulation by the civil code, if it is null and void, it must be restitution. All of the parties must return to the previous stage. Yet the plaintiff returned no funds. Yes, it was his mistake, but he returned no funds. The decision of my eviction and eviction of my family was challenged to the Court of Appeals, and also no final decision was taken. Our eviction indeed took place. We speak of the period of time after the Court of Appeals it gained the legal power, and you continue residing before Cassation Civil Court within the Supreme Court has supported the same decision. I beg your pardon? The period of May 2023 till August 2024. In August 2024, Cassation Civil Court supported that decision. Immediately in May of 2024, I have challenged the decision, and of course, before the appeals instance, I believed that this decision did not gain the legal power. In confirmation of that, we can refer to the Unified Registry of Pretrial Investigations, because immediately in May, not waiting before the end of appeals is over, I was removed from registration. I filed an appeal. When appeal proceedings has started, I believe that the appeals court has full legal grounds to be on my side, on the side of the defendant. I referred that we are renewed in our registration to the Center of Administrative Services of Krasnopilya Village Council. The Center of Administrative Services refused, because during the wartime it was not necessary to have the judicial proceedings. The application was sufficient, and they referred that there is an application of the owner. Accordingly, after failure to respond to my statements, I have filed also the statements about the failure to fulfill the judicial decision, because by the verdict of appeals court, the executive proceedings have been stopped. Also by decision of the cassation court, the decision of the Velika Pisarivka district court has been suspended. And you did not move from the house. Yes, indeed, because I believe the matter is still open. You have explained that you have followed the court decision. Quotation from your explanation addressed to the advisory group of experts. The court decision as formalistic and controversial. To your mind, you as a judge, do you have to make such comments about the court decision which gained the legal power in the name of Ukraine? And you referred to the article of the Constitution according to which the judicial decision is mandatory. Decision of the court is mandatory, is legally binding. Indeed, yet if we take one circumstance, at least our malafide behavior, which was disproven by resolution of Supreme Court and yet was stated by the decision of the first instance court. In a summary, the agreement is null and void, and this house is no longer my property. I do not challenge that. I don't have legal grounds. I did not have legal grounds to declare even this property, because the legal grounds for that have been absent. It's not about circumstances of the case, but you yourself is a judge, and now you make this comment of the court decision, which gained the legal power. To your mind, is the behavior in conformity with the code of judicial ethics? Can a person who is a judge make such a comment of the court decision which gained the legal power, even if this judicial decision is against such person? I believe if there are grounds for that, that's possible. I have one more question. Why did not you represent in your declaration the fact of residency in that house after you lost your title and your legal grounds for residency? According to the explanations of the National Agency for Civil Service and National Agency for Corruption Prevention, I had to represent all of the property. I had to could confirm with the documents, or at least the extracts from the Registry of Real Estate titles. The declaration must represent the place of residency where do you have legal grounds for residency and not the actual residency. Mr. Vitalii, on 28th of February of current year 2025, you have been held administratively liable for residency with no registration. How you can comment this? You are the judge, and you allow the situation when you are held liable in the administrative way for this ground. I can only repeat, I did not have, and currently I don't have any home, neither owned by myself, neither rented by myself, properly formalized. Therefore, we have lived in that building that we have bought and then lost based on the court decision. However, getting registered in it from May 2023, despite of my efforts, was not possible. In another house, also, other options of registration we did not have until the month of February, when we got registered in the estate which belongs to my mother. You didn't have any other residential premises, did you? That's fine. The next question. In August 2020, you have been appointed as a judge of Krolevets, District Court of Sumy Oblast, and the building that we have discussed till now is in the village of Krasnopilya of Sumy district of Sumy Oblast. The distance between those two municipalities, depending on which motorway to take, from 190 to 250 kilometers. Could you please tell me how could you carry out the responsibilities of the judge by driving every day such a big distance? Or didn't you have to travel every day? I have provided a written explanation. Once a week, yes, indeed, you gave the explanation. But today we speak for everyone, for everybody, all the members, deputy members of the advisory group of experts, and also those people who are watching this broadcasting. From Krasnopilya to Krolevets, I drove once a week or once a fortnight. Where did you live in Krolevets? And why, in this case, you did not represent that place of residence in Krolevets in the declaration? I didn't have rental agreement. I didn't have a rental contract, no other agreements. From time to time, I lived with people with whom I have agreed in a spoken way. I paid for the room. I paid for my lodging. According to the law, if you live for more than 183 days during the year, you are obliged to represent that place of residency in your declaration. We have analyzed the registry of judicial decisions for the year 2023-2024. The days when you have taken at least one judicial decision. In the year 2023, such days 194. In 2024, 207 such days when at least one decision was taken. By reviewing the cases, taking judicial decisions, you remained in Krolevets during such a period of time for which had to be represented the place of residency of in your declaration. Why didn't you do it? Because those were different premises. And no legal grounds for residency there you did not have, neither rental agreement nor the hiring contract. Now I would like to give the floor to my colleague, Madam O'Connor, and after that I will continue with more questions.
Clarification, there's been a lot of discussion about declarations and ownership of the property that was that belonged, I guess, is the Makarenko house. Did you ever declare that you were living in that property as a family unit with that he was your family member in your declarations?
Ні, пан Макар
No, Mr. Makarenko was never considered as member of my family. In the understanding of the law, which defines the procedure of declaration, family members are persons related with common household, if not even family relations, yet we had different households, separated.
Was the fact that he was in a separate part of the house with a separate and it was an addition to the house that he lived in rather than with you and your family. Is that the basis for that understanding?
так, саме так.
Yes, indeed.
Topic of the ownership and the declarations for that piece of property. Mr. Romanuk?
Дякую, пані Оконор. Віталій Миколаївич, наступний.
Thank you. The next block of questions is about the review of cases taken of decisions by yourself as a judge in line with Article 130 of the Code of Ukraine on Administrative Offense. This article sets liability for driving transport vehicles under condition of alcoholic or narcotic intoxication. Ukrainian legislator established 1 year of time in order to review such a case. The advisory group of experts analyzed for the period of 2021, 22, and 23 this category of cases that you have reviewed, Mr. Vitalii, and we have found at least 9 cases on which the cases have been in the proceedings for at least 11 months, and finally have been closed due to the expiration of time for holding the offender liable. And in any of the judicial decisions, you made a comment why, during such a lengthy period of time, the case was not reviewed. What were the obstacles that deprived you of the possibility within 1 year time, as established by the law, which is a lengthy time, to review such a case? What would be your comment? How could you explain that during 11 months you could not review the case? And finally, the persons who drove transport vehicles in alcoholic intoxication were not held administratively liable. Shall I read for every case? Not for every, but a general answer, please. The point is that in the year 2021, yet there have been fresh memories from the School of Judges, and there was a clear instruction that we don't have to violate the right to defense. Therefore, when a petition was received to postpone the case in line with Article 130, while understanding that it does not imply mandatory participation of a person, but if a person or the lawyer, and in those cases there have been lawyers, filed a petition that they have been sick, they have another case, the court satisfied such petitions. Myself, as a judge, satisfied such petitions. Moreover, most of such cases, I must admit, have been in the difficult period for myself due to coincidence of difficult circumstances. When in October 2024 I was sick, I had COVID-19 of the Delta strain, and for about 2 months I have been in a hospital. And the disease was hard. I have lost 2 months, and then I am sure that once again, like the public and advisory group of experts has the opportunity to analyze the other cases under Article 130, the cases of driving the vehicle in the condition of intoxication, when no petitions have been filed, or when people arrived personally, or when the police agency have brought people to court in line with my request. The cases have been reviewed. However, in the cases that you have mentioned, this did not happen before 2023 February. Briefly speaking, the reason was to ensure the right of defense for their offenders and your lengthy disease. Not only, starting 24th February 2022, we had to remove such cases from the review, and only when a signal was given that we can renew those cases and review them. And yes, such instruction was received in the end of June, and in most of these cases the term of review has expired. Yet I have reduced some of them. Another case on Article 130, number of case 579/2022 2238/23. On that case, you have closed the proceedings on the case for the absence of the event and the composition of the offense, because the person drove in alcoholic intoxication the electric scooter. And you referred to the decision of the Supreme Court. At the same time, the analysis of this decision of the Supreme Court demonstrates that actually that phrase was driven out of the context of the decision of the Supreme Court, because in the same decision of the Supreme Court, it tells that any transport vehicle which is driven with the engine, regardless of its working volume, belongs to mechanical transport vehicles. How you could comment on this? Moreover, this decision was made by you in November 2023, and yet in March of 2023, the Supreme Court, on another case, made a conclusion where it tells that the use of an electric scooter for transportation of a person as participant of the traffic is a source of increased danger. Why, in presence of such clear and unambiguous legal conclusions of the Supreme Court, you set a person free from administrative liability? Resolution 579, 2238/23, which was about administrative liability in line of Part 1 of Article 130 of the Code of Administrative Offenses, is not contradictory to the practice of Supreme Court, because in the Supreme Court it was a civilian case where the electric scooter is a source of increased danger. Of course, it's a logical and appropriate decision that indeed it is the one, because such recognition was necessary for delimitation of the grounds of holding people liable in a civilian way for the results of traffic accident. The question which was put before the court by the defense lawyer was different, whether electric scooter can be considered a mechanic transport vehicle. In particular, according to the paragraph 213 of the traffic rules, transport vehicles belong to category A1, A, B1, those which can belong to different types of motorcycles and other two-wheeled transport vehicles with engines on small volumes or electric motors, according to the paragraph 10 of the traffic rules. So this is your way of interpretation of the law, and you believe that your decision was right. Of course. The next decision on the case 579/332/24. On the Article 126 of the Code of Ukraine of Administrative Offense, in particular, driving by a person with no proper license for driving. On that case, you cancelled the resolution of the employees of National Police about administration of administrative penalty and closed the proceedings in the case. In the future, the appeals court disagreed with your decision and cancelled it. What would be your comment about the circumstances of this particular case?
You made the mistake, or you still think you are right? According to point 5.2 in the instructions of National Police, Vitalii Mykolaievich, you don't need to quote. Please, you think you did right? Appeal court made a mistake? I think that my decision was based on the legal norms of legislation and the circumstances that were brought to the first instance court. Thank you. I will further give the floor to Ms. O'Connor.
I'm going to move on now and talk about letters of recommendation that were submitted on your behalf. In your motivation letter in the competition for the position to be a member of the High Qualifications Commission of Judges of Ukraine, announced by the decision of the Competition Commission for the selection of candidates for the position, members of the High Qualification Commission of Judges of Ukraine, you added recommendations from 3 people. Are you familiar with those recommendations by those 3 people?
Так, знаю.
Yes, I know. Yes, I know.
3 recommendations were almost identical in their content and the writing, the style of writing. So the question is, did these people these 3 individuals who gave you these written recommendations, did they write the letters themselves, or was the content and the wording supplied by you to them?
I need to admit that when they asked me, they gave the template, what should be the content of the recommendation letter. I have provided this template. They didn't do it in that particular order, but they have taken a lot from this template, correct? Because this is not the trivial task when you ask to write about motivation task. It's not a trivial task. Even for experienced lawyers, at least for those that I know and whose opinion I highly appreciate.
People that had engaged with you professionally. They were lawyers that had practiced in front of you. All right. So indicate or explain under what circumstances is your relationship with one of the lawyers, and it's Vernehova Valentin Mikolovich. And do you maintain or have you maintained friendly relations with this lawyer, with him? Is he a good friend of yours?
Yes. Okay. With the lawyer Vernehora, I met him in 2020. Prior to this, he worked in Korolevetsky court, but there the periods of our work, we probably never, our time schedule never coincided. We never our paths never crossed. Friend. Okay. With it's not recommended for judges to keep friendship relationships with lawyers. I cannot say I have friends among lawyers or defense lawyers in Korolevets community. I cannot say I'm friends with him, but lawyer Vernehora is one of not many other lawyers. This is the person who in work he deserves respect, and he is doing a good job in defending. Since motivational letter it was required from the experienced lawyer, I appealed to him, to another lawyer as well. Another lawyer that I appealed to, she did not agree to give motivational recommendation letter, because she was going through the contest herself, competition for the position of the judge. That's all I can say. Friendship relationships, no. Unfortunately or fortunately, I don't know.
The letter of recommendation from this lawyer, it's known that you have repeatedly considered or continue to consider more than 30 cases where the lawyer, Vernehora, was or is a representative or a defense attorney to a party in a case that is before you. So I guess the question is, why in the vast majority of the cases that you closed, in the absence of an event and the elements of the administrative offense, those cases on bringing persons to administrative liability for violation of Article 130 of the Code of Administrative Offenses, in which this lawyer participated. In other words, this lawyer is recommending you, doing you a courtesy or a favor by recommending you, and you continue to preside over his cases. Is that a conflict?
As much as I remember, the rules of submission to these recommendation letters, the person that I rely as a recommendation person, the person even now he can give bad recommendation to me. So to think that I was obliged and I had to I had to be under influence of this recommendation. No, I had no reasons to think that. Speaking about the closure with the absence of cases, not the lawyer Vernihor Ra was doing professionally his job when there were defects and mistakes of the authorities who didn't provide enough evidence. The same video recording that they asked me not to refer to. In that case that was mentioned about driving without license, there was the pause. In the video recording, there was the pause, which was banned because they could do whatever they wanted to in this pause time. So it was if the defense party refers to this recording with the pause, this is not the ideal evidence because protocol itself is not sufficient evidence, is not the set of evidence to bring to liability according to the administrative offense.
So your position then is that you did not need to recuse yourself from any of the cases that, any of these 30 cases because of your relationship or your acquaintance with the attorney Vernihor. It wasn't necessary in your mind. Is that accurate?
Yes. Yes, you understand me correctly.
Well, let me ask you further then, were the parties to the cases aware of the fact that that this attorney had provided a positive recommendation for you in competitive procedures? And did the parties file motions for your disqualification in any of those cases? So the question is, did they know of this recommendation by this attorney for your benefit? And if they did know, did any of them file motions to have you recuse?
Informacja про
Information about recommendations is all generally accessible on all websites. So, of course, they could find out about the decisions in any, all the information is on website of the judicial branch. I did not inform personally. I didn't think that would be right. The circumstance that could affect on me, it could affect me positively or negatively, as before giving recommendations and after recommendations in many different cases by me. The lawyer Vernihora. Yes, there were some refusals. So I did not inform parties. Did parties know? They had opportunity to find out, but I don't know. Nobody gave me that explanation.
Saying is you didn't mention it or tell any of the parties involved of the relationship, and none of those parties found out about it in such a way that they then asked you to step aside or recuse yourself or disqualify yourself from presiding over the case. Is that an accurate statement?
Look, right now we are talking about cases. In majority of cases, we're talking about offenses, administrative offenses. According to our practice in administrative liability, another party, the party that presents administrative accusal, this is police or prosecutor's office, they don't even show up. The authority, we cannot disagree that from the side of Vernegora, the authorities, they have all possibilities, more possibilities than ordinary citizens have to find out and know that recommendations were received by me from this lawyer. They should have come and they should have stated about the so we could not take this situation as such because this is the misunderstanding that the other party, these were persons who are at the same procedural level. And the Court on Human Rights, they say that administrative liabilities, is especially under Article 130, this is the kind of criminal proceeding. So the party of prosecutor's office, police force, they are they are prosecutors, and they have competencies and they have possibilities of the defendant. So I cannot probably explain anything more. If you have any more clarification questions, you can ask.
I'm just wondering, did it give the fact that you were the recipient, the beneficiary of a positive letter of recommendation from a lawyer who is practicing in front of you, and would it be reasonable for an outside observer to have doubts about your impartiality, your integrity as a judge, and the judge's, adherence to ethical standards? I just find it rather suspect that wouldn't have been a requirement for you to disclose that. I know you say, well, they could have looked and they could have found out that this lawyer wrote recommendations for me for this position, but is it their responsibility to do that, or is it your responsibility to disclose that? And if you don't think it was your responsibility, why not? Why don't you think that was your responsibility?
As I have mentioned before, I did not think, and I still don't think, that those recommendations would have affected me, or they are even now affecting me. Moreover, as statistics shows, which is not easy, not hard to find, in the majority of cases where lawyer won or lost, there are both cases, positive and negative decisions. So his participation in the recommendation letter did not have an effect on me. It did not. This letter did not mean if there is a non-professional work from the side of lawyer, if the work is not sufficient, or there are not sufficient evidences for the decision-making process in the trial for his client. So responsibility would be mine if I considered that this recommendation would have affected me. But it does not affect me at all. Secondly, if I had considered that this recommendation would have affected me, and it, as far as I understand, this interview means much more than a recommendation letter. Moreover, if I thought this recommendation letter would have affected on anything, maybe I would have thought, but then I would have to refute. If the judge who understands that he is under influence of the lawyer, that he's the first judge, is the first one who needs to know about the requirements, about the refuting. So it's his responsibility to declare about this, or he had to at least raise this issue. Not to inform, disclose that, oh, I was given the recommendation. The worker of police force, he gave me a ride for 10 meters to the facility of the court. If, I'm just talking hypothetically, police officer, excuse me, they never give me rides. That was a hypothetical situation. But it's a small town, the circle of communication is limited. So no, I don't think that this would be my responsibility to inform, to disclose that I have received such a recommendation letter.
What, Chair?
Required to disclose it if you knew that that recommendation letter prejudiced your handling of the case. In other words, you were doing a favorable or looking at it more favorably for this lawyer. But is that really the standard? Isn't it what would a reasonable party, what would a reasonable citizen think if they knew that the lawyer in the case had given you a favorable recommendation for the position of that you were in competition for? So I understand what you're saying, and I think we all understand what you're saying, but I don't know that I would necessarily agree with your perspective here, that you would only be required to disclose it if in fact it influenced you. I think it's maybe a bigger obligation than that. But I will now relinquish the questioning back to Mr. Romanov.
Дякую, пані Конор.
Thank you. Mr. Vitalii, this is not the first competition where you participate. Previously, you took part in the competition for the position of the member of High Qualification Commission of Judges of Ukraine. And among the other questions that you received, one of them was, what ethical values will it be most difficult for you to observe in case if you are appointed member of the High Qualification Commission of Judges of Ukraine? You replied that most difficult is taking decisions or taking actions otherwise under political and administrative pressure. Do you have any experience of this kind, taking decisions under political or administrative pressure? Luckily, I don't have. In your communications with the advisory group of experts, you quoted that you believe it was a form of influence on you, the complaint of the citizen Boychuk, Petro Volodymyrovich Boychuk, who filed a disciplinary complaint to the High Council of Justice. Why do you consider the complaint of Mr. Boychuk that this is a form of influence on you? This complaint was filed by the person who was not party to the case, and he had no lawful interest in those 9 cases under the Article 130 that we have just discussed. Therefore, I believe that in principle, filing such complaints is excessive. Why is it a pressure against me? Because if you refer to the complaint, a substantial part of it is that the complainant is emphasizing that this complaint is subject to priority review because this is a judge who participates in the competition for transferring to another position. Not in this competition, but in the competition for transferring to another court. Selection of judges for courts of the first instance. And this is how Bychuk motivated this complaint. You explained that as Mr. Bychuk was not a party to judicial review, accordingly he could not make a disciplinary complaint against your actions. Is it right to understand that, for example, shall we model a situation if a judge commits unethical behavior in his personal life, other citizens cannot complain against such actions of the judge because they are not parties to judicial review which are in the proceedings by the judge, right? It depends whether there is a composition of another violation in the activities of the judge. Maybe it's a composition of criminal offense, administrative offense. It's about unethical behavior. It's not even up to criminal offense. In that case, you should be more specific. What kind of unethical behavior do you mean? Your response depending on particular circumstances of the case. Yes, this is my answer. Now, Madam O'Connor will continue.
A little short of time here, and I'm going to condense my questions with regards to participation in educational events on the days of court decisions. We have 6 examples from starting, I think, in 2021 through 2022, 23, 24, and 25, where you participated in training. And the training that you took, the seminar, was anywhere from a 40-hour seminar, which would be over several days, to a 6-hour seminar, and the majority of them are 6-hour seminars. And looking at the time and the date and the location of when you were taking these seminars, you were also issuing orders in open court sessions and adopting decisions on the very same day. This looks like it happened on May 28th of 2021, February 18th of 2022, March 10th of 2023, January 9th of 2024, and January 17th of 2025. So you were issuing opinions, resolutions, making decisions in open court on the same day that you were participating in training for judges. So explain how you combined the exercise of the power of a judge with participation in the above mentioned seminars, educational events, when you take into account the possible need to travel to the city of Kharkiv, which I understand is about a 5-hour travel by car. So how do you explain this?
Як протягом
During the quarantine period in Ukraine and also during the martial law, the training events took place in video conferences. In the written explanations, I have explained in detail that I have held the meetings or I took decisions. Mostly those were in written proceedings with no open court session before the training or after the training. As for the training, I took part in video conferences from my office, from my own office as a judge. In those period of time where classes took place, I did not review any cases.
And these were by use of, as you said, video conferencing for the training, and then you had the opportunity on the same day to hear a case and to rule on it, either before or after the conference on that day? Okay. All right. Mr. Romanek.
Дякую, пані Оконор. Віталій Миколаївич, і наостанок ще одне запитання.
There is one more question. As we discussed, this is not the first competition that you participate. You took part in the competition for the position of a member of Higher Constitutional Commission of Judges of Ukraine, the judge of the Higher Anti-Corruption Court. This is what we found. My question is, what is your priority? Do you have any priority? Or simply we are trying to move anywhere from Krolevets and preferably higher commission, higher court, or constitutional court? Where is the priority? It happens that for the last years, I am absolutely sincere. For the last years, I had so many opportunities for the lawyer who wants to make a career and to achieve something and to become influential. Myself as a judge for several years, I'm working for, I believe that I work with high quality, taking into account the number of cancelled and challenged decisions. And yet it means also stagnation, because any competition, both for the anti-corruption court, this is a challenge. Also, the Higher Qualification Commission. Indeed, it was interesting for me. I had interesting experience. In particular, participation in this competition also makes for me certain challenges. In case I successfully pass the competition, this will be absolutely new sphere, absolutely new tasks that would require some special efforts. This will be non-trivial, even taking into account the width of types of cases reviewed by judges of the first instance, yet the Constitutional Court reviews the matters which are paramount, which are the key ones, which are covering every sphere. To the extent I'm familiar with activities of the Constitutional Court, it covers every sphere of life. You would like to grow professionally, right? Yes, indeed. That's it. I don't have any more questions. Dear colleagues, do you have any more questions to the candidate? Unless you have questions, dear Mr. Vitalii, you have 5 minutes for the final statement. I hope that the advisory group of experts will support me, and I'm lucky this time. Having in mind it's 6th of January, or 6th of December today, in my final word, I would like to congratulate on the occasion of the Day of the Armed Forces of Ukraine. This date is quite important. Thank you, that's it. Thank you, Mr. Vitalii, for your replies, and also, dear public, saying this, the interview with the candidate to the Constitutional Court, Mr. Prydatko,